presence of the jury.
The subpoena that Mr. Friedman served on Ralph Otto and the entire civil board fleet that he did not share with us, I can share that with you too.
Your Honor, if I may respond to that, my cover email to Mr. Otto states, "It is our understanding that you may be arriving in Florida to testify. When you land, we intend to serve you with a trial subpoena, requiring your attendance, and that requires you to bring certain documents with you when you testify. To that end, we are attaching a courtesy copy of our intended subpoena in advance so that you can have more time to gather the documents, and then when served, it will make compliance easier for you. We then ask him to tell us when he's arriving to make it more convenient for him and the process server, or ask if he will accept it over email. This was not service of a subpoena. This was service of a courtesy copy so that when he landed, we would hand it to him and then we would bring it to your attention to say, and to them, and to say, hey, we have now tagged Mr. Ralph Otto in Florida with tag jurisdiction. He now has a valid trial subpoena to produce documents to us. We were never able to tag Mr. Otto, and so we never ended up serving the subpoena. I was very clear it was a courtesy copy, so I take issue with Mr. Axelrod's half disclosure to the court about what I did. Also, Your Honor, I must take a moment to correct.
Before you do that, is that what the cover letter said?
I don't have the cover letter in front of me, but there's a certificate of service that says, I hereby certify that the foregoing documents was furnished to all counsel of record by electronic mail on this 6th day of January 2025, the same day that it was sent to Mr. Ralph Otto. And it was never served on us.
Your Honor, may I approach? Here's the cover letter. My paralegal prepared a courtesy copy. It says, on my honor and as an officer of the court, it was a courtesy copy. We said it straight out. It is true there's a certification in there, but that's just because I asked my paralegal to prepare a subpoena so we could send it to her. She simply filled it out. Your Honor, also, if I may just, I feel compelled to simply correct the record because my client has been labeled a liar over and over again. The document, Mr. Young said it was a wet signature, and as you'll see on the document, it is not signed by Helios Global, which means, as Your Honor pointed out, he executed it and then sent it, he mailed it back to Helios Global for execution, so he did not have it to produce in discovery. My client has never lied in this litigation, and in fact, when asked about whether he signed an agreement with Helios Global, admitted it on the stand. Mr. Axelrod was not prepared for that admission, went to impeach him after there was nothing to impeach. And if the court looks at the transcript, you'll hear my objection. He says, I'm going to impeach him. And I said, what are you going to impeach him for? There's nothing to impeach. So he has told the truth over and over and over again. The only thing he hasn't told the truth about is that he didn't know that as of 2022, Helios dropped his security clearance. He had no idea. CNN knew and failed to produce those documents to us when they obtained the documents from Helios Global. And, Your Honor, then when the court inquired about how CNN obtained these documents, CNN lied again by saying it was just luck, that it was just sheer luck that we got it. It was not sheer luck, Your Honor. It was the secret subpoena that was sent out. When the court looks through the questioning that you've just seen, you will see that Mr. Axelrod left the jury with the impression that Mr. Young was doing contracting work with Helios Global, something he knew was not true. And which echoes the statements he made to you about Mr. Young committing a fraud on the court, which of course is not true as well. So, you know, and in terms of not listing Helios Global as a witness, of course we didn't, because we didn't have this document, Your Honor. This document was obtained outside the bounds of discovery. It was hidden from us. It was thrown at us as a surprise. We are now prejudiced, and the relief we're looking for, quite frankly, Your Honor, is conservative in my view.
They were not prejudiced, Your Honor.
And Your Honor, they put an expert on the stand yesterday that said he still has a security clearance, he's great for, he can do all the work he wants. They knew it's not true. They had their expert get on the stand and say, he's got a security clearance, no problem, he can get work. They knew it was not true. We did not, they did.
That is false. Mr. Young testified he still has a security clearance. We had no idea that that's not true.
Your Honor, if I may, they knew it's not true because Helios Global told them it's not true on January 2nd, 2025. In their letter, they said, we retained Mr. Young's clearance through approximately November 2022 in the event these requirements reemerged. But they did not. Ultimately, we administratively dropped Mr. Young from our security clearance roles, thus ending any relationship/affiliation. So CNN knew that there was no security clearance in place, something we didn't know because we didn't have this communication.
Well, they knew you didn't have it through Helios Global.
Correct.
Well, that's true, Your Honor, but that is, I mean, Mr. Young's testimony has it through no one else, and what his testimony on the stand was that Ian Conway did him a solid by keeping his security clearance, and I hope I still have it, if I remember correctly. I'm trying to remember. So clearly, Mr. Young's testimony was the security clearance is through Helios Global. And that was the only evidence that there was a security clearance. CNN knew that that relationship ended, knew Mr. Young did not know that that relationship ended, had proof of it and failed to disclose it to the other side, and then put an expert on the stand to say he still has it. Your Honor, I'm not sitting here asking for sanctions. I'm just saying we have been massively prejudiced, and we should be able to clear the record. The jury should not be misled.
Mr. Friedman argues that Mr. Young has been prejudiced and asks the court for an opportunity to clear the record before the jury. The asserted prejudice concerned the evidence on compensatory damages, the money that a jury awards a plaintiff to make them whole for losses that were caused by the defendant's conduct. In this case, a central question for the jury was whether Mr. Young remained employable after the broadcast, and CNN has maintained that he continued to be employable. In support of this position, CNN pointed to the 2021 consulting agreement that Mr. Young had signed with Helios Global, and by expert testimony that he still held an active security clearance and could obtain work. Mr. Friedman contended that CNN possessed a communication from Helios stating that Mr. Young's clearance had been administratively dropped in 2022, that CNN had never disclosed it, and that Mr. Young himself did not know that his clearance had ended, leaving the jury with a false impression on the issue. Now, because Mr. Young had already rested their case at this point in the proceedings, the request functioned as a motion to reopen the case so that they could introduce the recently disclosed Helios Global communication and call a company representative in to testify. The decision to permit a party to reopen its evidence rests with the trial court's broad discretion. As the 5th District Court of Appeal explained in the 2011 case of Grider Garcia v. State Farm Mutual Automobile Insurance Company, a court weighing such a request must consider the timeliness of the request, the character of the evidence sought to be introduced, the effect of admitting it, and the reasonableness of the excuse for not offering it earlier. Applied here, Mr. Friedman's request was made the day after the plaintiff rested, the evidence sought to be introduced was material to the issue of damages, and due to the timing of the disclosure of the communication, it seemingly could not have been offered earlier.
Your Honor, you can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it. Can't produce it. That's what happened here. I mean, he got the contact.
I sign a document, send it off. It's within the company's possession, custody, or control. What is my discovery obligation to go to their records, dig through their files, and find a copy of a document I signed several years ago?
But that's not what I was suggesting, Your Honor.
It was.
What I'm saying-
It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it.
He had it, is what I'm saying.
I get the court reporter to read back exactly what you said, but I think I verbatim said exactly what you said.
Your Honor, the point I'm trying
I'm
to
tired of these blatant misrepresentations that are being made, and they're being made by both y'all. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth and making representations so you can carefully say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but he had no proof that he had work because you're arguing that he signed the security agreement so they could hold his security clearance. Well, I didn't lie and said he had work. All right, we're taking a break. I'm going to go read this real quick. Let me ask you one last question, Mr. Axelrod. You said, we were going to call Helios Global or whoever it was from there as a potential rebuttal witness. And that's why we served a subpoena. We didn't need to list a rebuttal witness on our exhibit list. But you also had production of documents from non-parties. And I remember reading 2 motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How are you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
Judge, I'm going to take ownership of that. When I called Mr. Friedman this morning after reading the motion, I was asked to prepare a trial subpoena, and the subpoena came across my desk. My paralegal asked me if we needed to send notice of this to the other side. I told her, no, it's a witness subpoena in 38 years. I've never served copies of witness subpoenas to the other side. I don't recall getting copies of witness subpoenas. I was looking at it as a witness subpoena, not a document production request. There was a ducus tecum component to it. I don't recall seeing it, but it was there, and I think, I'm responsible for that. So if the rule requires notice of a witness subpoena that has a document production request to it, that's on me, and I take responsibility for that. And I told Mr. Freeman that.
All right, well, and Mr. Axelrod made the representation that fortuitously we ended up just falling into our lap at the last minute. But it wasn't fortuitous because it was pursuant to that witness subpoena.
That is true. Mr. McManus did send it, but we did want him to come testify. That is correct.
All right, I'm going to go look at this. I'll be back.
Judge Henry questions Mr. Axelrod about why CNN obtained documents from Helios Global, a non-party, without giving notice of the subpoena to the plaintiff. A standard trial subpoena commands a witness to appear and testify, and on its own, it does not trigger the rules governing document discovery. A so-called subpoena ducis tecum, by contrast, commands the recipient to produce documents or things, and when it is directed to a non-party and no deposition is sought, its use is governed by Rule 1.351 of the Florida Rules of Civil Procedure. The rule requires the party seeking production to first serve notice on every other party of its intent to serve the subpoena, with a copy of the proposed subpoena attached before the subpoena issues, so that the other parties have an opportunity to object. The rule also states that it is the quote-unquote exclusive procedure for obtaining documents from a non-party by subpoena without a deposition. Here, CNN served a subpoena requesting document production on Helios Global without giving the plaintiffs any notice at all, let alone the advance notice that Rule 1.351 requires before a subpoena ducis tecum may be issued, which is in violation of Florida's discovery rules.
All right, I went back through and I was reading the trial transcript that preceded the sidebar and then adjourning with the jury and the discussions that we had with the Helios document that was handed, 589? I think defense 589 was the document that was handed to Mr. Young during the cross-examination. I think I made comments throughout the course of this case about how counsel was conducting themselves, how everything was a surprise, a last-minute thing, how counsel was referring to each other in the course of their arguments, had to impose a $100 fine. And I find it rich that we've got discovery being done at the same time a motion to quash is being filed, arguing that the plaintiffs are violating the rules by sending out trial subpoenas when the defense is doing the exact same thing. We have representations being made to the court that we were just fortuitous to get this. It wasn't fortuitous. It was you were doing the same thing that the plaintiffs were doing and sending a trial subpoena for documents without notice to the other side in violation of Rule 1.351 that y'all cited in a couple motions, and just saying that this showed up in our lap. You represent to me this morning, we didn't accuse them of anything, of having anything beyond a security agreement, but that was clearly the implication that was being made when we were arguing about the document, because you wanted to impeach him with it, despite the fact that he admitted to signing a security doc. Then you changed it, we want to use it substantively, and it got admitted into evidence. And it was admitted into evidence under my Binger analysis of something that, there's not prejudice to the other side, was primarily the reason. Had I known it been discovery being conducted after the deadline, there was no way in hell that the document would have been admitted into evidence. Mr. Axelrod, I don't know how many times in this transcript I didn't bring this paper back with me, how many times you called Mr. Young a liar. But yet in his deposition, he acknowledged having his security being held by Helios Global, which is exactly what that document is and which was exactly what he testified to. I make an apology from you. It was clearly in order to Mr. Young for the number of times in front of this court and streamed around the world that you call Mr. Young a liar for failing to disclose a document that you have no proof was within his possession, custody, or control.
Judge Henry admonishes Mr. Axelrod for repeatedly calling Mr. Young a liar because he did not disclose the Helios agreement, despite having no evidence that the document remained in Mr. Young's possession. Under Rule 1.350 of the Florida Rules of Civil Procedure, a party's obligation to produce documents extends only to those within its possession, custody, or control. A party cannot be compelled to produce a document that falls outside that scope, and the absence of such a document from a party's discovery responses is neither a violation of the rules of civil procedure procedure nor evidence of concealment. Here, Mr. Young had signed the agreement and had returned it to Helios Global for execution, which placed the document in the company's possession rather than his own. He had acknowledged signing it and that his security clearance was held through Helios, so its existence was never hidden. Because the agreement was not within Mr. Young's possession, custody, or control, he had no obligation to produce it, and its absence from his discovery responses gave no support to the accusation that he had lied.
You know, everybody here, I don't know how much money we're clicking off an hour in lawyer bills in this case, and how much credentials the lawyers have in this case. The case has been pending for 2.5 years in my court, and I made a joke, looking back through this transcript, I made a joke of you only have a week and a half to do more discovery in this case till we finish up the trial, but it seems like everybody wanted to do everything at the last minute without telling the other side that we're going to do this discovery and then accuse the other person of being the bad person. And I said in this transcript, I'm not going to decide the case based on who can sling the most mud at each other and make each other look out to be the worst person. I think it came up in the course of things. This isn't kindergarten. Y'all matriculated from kindergarten a long time ago. Or at least that's what it says because y'all have bar licenses. I'm troubled by all of this to happen. The easiest thing and the clear thing I'm doing is I'm permitting you to call Mr. Conway and get him here to testify in rebuttal. But I'm overly concerned with the level of professionalism or lack thereof that's here. I'm overly concerned. I mean, the transcript of what I read, we said at sidebar when we were arguing after we excused the jury, conflicts Mr. Axelrod with the argument you made today to me. The argument you were making when we were arguing about the document last week, we're suggesting that, oh, we got the smoking gun. This is the crucial document in our case. I don't know how many times I've heard that from both sides in this case. Or the crucial witness. Like every document, the thousands of documents we have in evidence in this case are the crucial documents. But this was being represented as, oh, this just fell out of the sky in our lab, not that we were doing the same thing we were accusing them of being bad people to do. And I take that as a complete insult to me as the court in this case. And you were saying that he completely lied and misrepresented despite the fact he acknowledged that he had his security clearance for Global, which again is another misrepresentation of the court, which supports your argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize if you feel that way. I apologize if you feel that I've misled you. That surely wasn't my intention.
Judge Henry also reprimands Mr. Axelrod for misleading the court about how CNN had obtained the document from Helios. Under Rule 4-3.3 of the rules regulating the Florida Bar, which are the ethical rules that Florida lawyers are required to follow, an attorney must not knowingly make a false statement of fact to a tribunal or fail to correct a false statement of material fact that was previously made to the tribunal by the lawyer. Likewise, Rule 4-8.4 prohibits attorneys from engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation. Mr. Axelrod's alleged representations that the pivotal document had surfaced by chance, when it had actually been obtained from CNN's own undisclosed subpoena, conflicted with the evidence of record. And as a result of this and other misrepresentations, including Mr. Axelrod's repeated attacks on Mr. Young's truthfulness based on the Helios agreement that we discussed earlier in this episode, Judge Henry informed Mr. Axelrod that he essentially had no remaining credibility with the court.
Yeah, well, you said, oh, I never said that. Well, no, you did. So today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against the lawyers and parties in this case. But at least to resolve the issue for this morning to go forward, you can get Mr. Conway here, and I'll do this too. If Mr. Conway cannot make it here, we can call him via Zoom. All right?
Nothing further.
All right. Is there anything else we need to get before we get the jurors in here?
You're on.
All right. And let me say this. I mean, y'all made a lawyer like that in Philly or New York or D.C. or wherever the heck it is, or Miami. We don't lawyer like this around here. Y'all may have handled some big cases. We're not going to play the shenanigans anymore in this case. Y'all both understand that?
Yes, sir.
And I'm upping the fine for personal insults to $1,000 per time from $100.
Judge Henry granted the plaintiff's request to reopen their case, permitting them to introduce the Helios Global communication and to call a representative of the company to testify before the jury. The trial then proceeded to its conclusion, and on January 17, 2025, the jury found CNN liable for defaming Mr. Young and awarded him $5 million in compensatory damages, consisting of $4 million for loss of earning potential and $1 million for pain and suffering, mental anguish, inconvenience, and injury to reputation. The jury also determined that punitive damages were warranted. However, before the proceedings to set the amount of punitive damages concluded, the parties reached a confidential settlement, the terms of which were not disclosed. This hearing demonstrates how an attorney's effectiveness can be impacted by conduct that has nothing to do with the merits of the client's case. As Judge Henry explained, the proceedings repeatedly broke down into accusations between counsel, drawing fines for personal insults and the open frustration of the court. That loss of control over the tone of the litigation served the lawyers poorly.